Well, I
hopefully by
believe it is
2025, right?
noon, and so we'll respect people's time and get underway. We're very happy to have Bryan Leonard of Arizona State University, an economist by training, with a particular interest, as you could tell from today's presentation, in property rights, and especially property rights in natural resources and environment contexts. And as you've heard, if you've been on for the last couple of minutes, Bryan is not a stranger to us. He's well known to our colleague Dean Luke, and he and one of his co-authors on this paper were here for WOW 6 last year, and we were happy to have him back as one of our 4 consecutive Commons related colloquium presenters this month. So our Commons theme continues. In this case, there's a particular focus on what a difference different combinations of property rights make. And a really interesting study where there are sort of different levels or different layers, as it were, of property rights available to people on adjacent parcels. So rather than steal any more of Bryan's thunder, I'm going to let Bryan do a little bit of introducing of his co-authors on this paper, and then get into his roughly 15-minute or so presentation of this paper, Property Rights Without Transfer of Rights. So Bryan, great to have you with us. And then I will moderate the queue for questions after Bryan's presentation.
Great, thanks, Bill, and thanks everyone for being here. It's a real honor to get to present this. Yeah, we presented the very first version of this about 18 months ago at WOW 6, so it's fun to be able to kind of circle back and show you what we've been up to. As Bill said, this is joint work with Christian Dipple and Dustin Fry, part of kind of an emerging suite of projects kind of around this topic of institutional barriers to development in Indian country. So yeah, as pertains to kind of the commons theme, I would characterize this as kind of maybe what can go wrong when we think about ways of bringing things out of the commons. And so in general, my work is motivated by thinking about property rights and how different dimensions of property rights can help us, help things perform better or worse in managing common pool resources. And so in terms of framing this particular paper, we're really thinking about kind of like, what do we know and what don't we quite know yet about how to title land when we're trying to solve common pool problems. So of course, there's a lot of work in economics and in political science that's really focused on kind of the exclusion dimension of property rights, but because that's so important for solving common pool problems, the ability to exclude others from sort of reaping the benefits of your labor. Of course, folks in the audience here, such as Dean, have contributed a lot to our understanding of how important the definition and demarcation of land rights can be for affecting transaction costs. And then really a ton of the economic development literature is focused on the security of property rights. Are your rights secure? Do you have an incentive to make improvements in productivity in the land? But what we're motivated by in this particular study, and I think it really is relevant for thinking about settings where we've used property rights as kind of a tool for addressing CPR problems, we're motivated by the kind of empirical fact that in reality, globally and in the US, a lot of quote unquote landowners who get property rights as a result of coming out of the commons actually only have what we call usufruct rights, or the ability to enjoy the fruits of the land. And so in practice, what that means is that they can use the land, they can make those investments, but they don't have full property rights in the sense that they don't have the authority to alienate or transfer the property right to another group or to another individual. And a lot of times this happens when a government has sort of competing goals. So they want to get the efficiency benefits of exclusion rights and security and closing the commons, these kind of things, but they're concerned about some type of commodification or some other sort of market-based outcome that we might be worried about. So you can think about this as sort of trying to get the benefits of property rights while shielding from very particular outcomes. And although we don't go into this in the paper because we're really trying to speak to kind of the economic development audience, this is actually really common in natural resource management. So in settings where property rights have been used to address CPR management issues, so you can think about water rights in the American West are very difficult to transfer. Those are pretty secure property rights in many cases, but there's lots of institutional barriers to transferring them. When we think about like catch shares or ITQs in fisheries, often there's restrictions on who can transfer quota to who or how much of it can be owned. Dean could tell you there's all sorts of restrictions associated with like hunting tags and other examples in wildlife. So this is actually a pretty common thing that we see when trying to use property rights as kind of a policy tool to address problems. And appropriately, it just so happens that today is Indigenous Peoples Day, which I think is great for this particular talk, because this is especially true for a lot of marginalized and indigenous groups throughout the world. So it's true for indigenous groups in both Latin America and sub-Saharan Africa, either because a colonial government imposed these transfer restrictions or because individual tribal chieftains imposed these restrictions. It's actually true of a lot of Black-owned land in the rural US South. And then it's true for a lot of land on the focus of today's talk, which is American Indian reservations. So I do want to point out that this is an issue that has been recognized in theory, especially kind of in the law and economics literature. Carol Rose has a wonderful paper about inalienability. But there's actually very little empirical work that in particular looks just at the right to transfer, and it's where it's not bundled with something like security. So there's a lot of good development papers where security and transferability are kind of linked, but this we think is a unique setting to look at just transfer rights when property rights actually are quite secure. So our motivating research question then to kind of sum all that up is just, what are the long run implications of inalienability for economic development in particular? And we'll talk about at the end, hopefully, some of those other goals that might trade off with economic development. But we really want to think about, what's going to happen in the long run if we impose these kind of short run constraints to get particular outcomes when we create property rights. To do that, we're going to study a historical episode in the United States. So about 1887 to 1934 is what we call the Dawes era. During this time, Native American reservations are kind of chopped up into 160 acre sized parcels, so a homestead sized plot, and granted to individual Native Americans and households. So you should think about the Dawes Act as sort of a compromise of sort of a classic bootleggers and Baptist style coalition. So you've got a lot of progressive reformers whose goal it is to assimilate Native Americans into white society, and they think that granting them property rights will help them become farmers and it will lead to economic development. Honestly, some of the justifications of the Dawes Act read a lot like kind of an Econ 101 textbook in that respect. At the same time, though, you have a lot of people moving west, a lot of white people moving west, looking for land. By 1887, I would say the first wave of homesteading had sort of passed through. And so there's a lot of folks that actually just want to be able to settle reservation land and not have it be reservation land anymore. So you have trying to get the benefits of private property, but this real concern that if we just give sort of fee simple title to Native Americans, they're going to get swindled out of their land by these white settlers. And so the sort of compromise that emerges is to allot this land to individuals, but to hold it in trust for a 25-year period, which is subject to some discretion that I'll talk about in a moment. But while it's in trust, it can't be sold. And because it can't be sold, it can't be alienated or seized, which means it can't be used as collateral. So I can't get a loan based on my land because the bank couldn't then come take it back because it's not really mine. It's held in trust with the federal government. Initially, it couldn't be written into an individual's will. And any sort of major change to like the contracts governing the land, so like an agricultural lease or something like that, would actually require approval from the local BIA agent. So in theory, this lasted for 25 years or until an Indian agent stationed on a particular reservation said that the individual allottee was competent, that's the word in the act, competent to hold fee simple title. So you go through this period where you have your land for 25 years, you can use it, but you can't transfer it. And after that, hopefully you get fee simple property rights. For a variety of reasons that are kind of outside the focus of today's talk, there's a lot of people that like aren't happy with how this is going by the 1920s. And so in 1934, the federal government passes what's called the Indian Reorganization Act, which does a lot of things. But one of the things it does is it puts a pretty much hard stop to this allotment process, and it freezes land in whatever status it's in at that time. So if you'd already gotten fee simple property rights, you were good to go. That land is in fee simple today. Some land had not been allotted yet, both within reservations, and then some reservations actually weren't ever allotted. And so they still have their land in tribal trust. But then a lot of land was actually stuck in this individual trust status where it had been allotted to an individual, but it hadn't been converted to fee simple. And so that's really kind of the variation that we're going to use in our study to understand the implications of these transfer restrictions. This is just a quick picture actually from a different paper of mine to give you a sense of kind of the when and the where of allotment. So these kind of cross-hatched shaded reservations like this one up here, or like I believe this is Fort McDowell down here, those were never allotted. The darker ones were allotted later in time, closer to 1934, and the lighter ones were allotted earlier in time, closer to 1987. So that's kind of what we're looking at in terms of the variation. Just a quick note to point out that in addition to kind of being of theoretical interest for kind of common scholars and property rights scholars, this is like a big deal for a lot of people. It really matters for the lives of a lot of people. Poverty on reservations is actually kind of staggering. So in 2010, we're looking at about a third of per capita income of comparable US counties. A lot of these places lack access to running water, electricity. So this is a real economic development problem. There's been growing work in the last couple of years, reaching all the way back to some work that Dean did in '92, thinking about this relationship between these land tenure regimes and other institutions on reservations and economic development. And if I could characterize that literature in like 2 sentences, it would be that we have a lot of kind of coarse reservation level evidence that reservations with one mix of property rights tend to do better with reservations than another mix of property rights. And then we have some really nice kind of high resolution parcel level case studies on a particular reservation looking at a particular outcome like oil and gas or irrigation. So what we want to do in this paper is kind of do both of those things. We'd like to have really nice kind of high resolution parcel level estimates of the effect of trust status on economic development, but we're going to try to do it for all the parcels across all the reservations. So to preview the results, because I'm sure I'll run out of time here, we're going to compare land use and land use change on fee simple and trust land and find that fee simple lands have about 0.2 to 0.4 standard deviations more utilization than trust lands today, and that translates into about $1,000 to $5,000 in land value per acre in kind of a back of the envelope calculation. We do this mostly by just trying to compare plots that are really close together and have really similar spatial characteristics, but we also develop an instrumental variable strategy really using kind of some weird features of the policy as it was enacted in the 1880s to help us make even more valid comparisons. And then we provide some evidence in the paper that at least part of this is being driven specifically by that inability to collateralize trust land and use it to get credit, which is sort of a classic economic development story. So to do this, I want to kind of highlight the data set that we borrow from, because it might be of interest to some folks here. This is actually kind of something I stole from another paper, a years-long project with Doug Allen that's based on General Land Office records. So the General Land Office is in existence from sort of the beginning of the United States through about the 1930s. And every time a piece of land transfers from being held by the government to an individual, it shows up as a record or a patent in the General Land Office. And in general, we know the legislation that was associated with it. Is it the Homestead Act? What is it? We know the name of the person that got it. We know when they got it. And importantly for this paper and some of the other work Doug and I are doing, we know exactly where they got it within the public land survey system. So this big grid that divides everything in the Western United States up into this nice kind of address we can find. So luckily for us, all of the Indian allotment records are part of, or sort of a subset of the General Land Office records. So we're able to figure out who got this land and where they got it. And importantly, we see sort of separate transactions for when they get the trust patent and if it ever gets converted to fee simple. So we know exactly when that happens. We use the fact that we can sort of locate these data down to a half mile by half mile, 160 acre square, to link it up with some satellite measures of land use. So for every 60 by 60 meter pixel, I know whether that pixel is developed, like is there something built on it? Is it a road? Is it a building? What is it? Are there crops planted there, or is it just sitting there kind of unused? And I can know that in sort of 5 decadal waves from 1974 to 2012. So this is going to let us do a lot to characterize land use. And in fact, Doug and I have sort of done this and built this data set for essentially the entire initial distribution of land ownership in the Western United States. And we're just kind of like sucking out a piece of that to focus on the land allotments today. We also use that spatial information to measure the elevation of each plot of land, as well as its ruggedness, as well as its soil productivity. So we know some basic things about, is this land going to be good for farming? Are we talking about a cliff? What are we talking about? And then for this paper, we're also going to bring in some sort of historical info about the allotment process itself and the allottees themselves. This is just a quick map of kind of where the data are for this particular project. So every little speck you see there is a 160-acre allotment. Happily, as you can see, they kind of trace out the boundaries of reservations, which tells us this whole mapping scheme is actually working. They are where we think they should be. We zoom in a little bit. This is what it looks like on the ground, so to speak. This is the Pine Ridge Reservation in South Dakota. These individual little squares are going to be our 160-acre plots that we study. Orange ones are still in trust status today. Gray ones got fee simple property rights, and the white is land that was retained by the tribe. So this gives you a sense of the kind of variation we're using to study land use. We're essentially going to be able to look at plots of land that are really nearby each other. Some of them got transfer rights, others didn't. Here's the outcome we're going to look at. This is the NWALT satellite land use data. Red pixels are developed. They have something built there. Green pictures are in some sort of agricultural production. Gray is essentially everything else except for water, which is blue. The thing we focus on most in the paper is this sort of standardized index of land use that we build, which basically says how much of the plot is being used either for development or for agriculture, so for some sort of productive use. Okay, so the main things we're worried about in making this comparison that I'll just touch on briefly, and then if there's questions, I'd be happy to to get into the nitty-gritty details, but we want to make sure that we're comparing apples to apples here. So we're worried that better land might get better or more complete property rights, that is fee simple rights. And we're also worried that certain types of individuals might be more likely to engage in behaviors that make them more likely to get a fee simple property right. And so basically we go through a bunch of steps in the paper to try to deal with this problem. Our main approach on the spatial dimension is to control for those land characteristics I told you about in a really flexible fashion, and then use really high resolution spatial fixed effects so that we're comparing plots in a smaller and smaller neighborhood to get our estimates. And then to worry about kind of what's going on with the people, that's really why we bring in the instrumental variable strategy. So just to give you a sense of the spatial fixed effects, on the left here, we have this 6 by 6 mile township, and these like tiny squares are our unit of observation. And we're just gonna cut these townships up into smaller and smaller subunits and include a fixed effect for each subunit. So like in panel C here, I'm only gonna be comparing plots that are within 2 miles of each other, and then I'm gonna average over all those comparisons to get my effect. This is one of like 3 tables, I promise, not very many tables. And basically what we see when we do that is that in our kind of most restrictive specification, we end up with about 0.2 standard deviations more land use on fee simple land than on allotted trust land. So that we view this as a pretty good estimate that sort of deals for the concern that better land might get more complete property rights, but we haven't really done anything to address the people. So I just want to summarize briefly what we do to deal with that. We developed 2 instrumental variables that should be related to whether you got fee simple property rights, but unrelated to who the people are and what their land use might look like today, or what their descendants' land use might look like, I should say. And the first is just the year they got the allotment. And the intuition here is that in general, if you got your allotment earlier, you're more likely to have fee simple property rights because of this 25-year kind of holding period. But when we dug into the data, we actually realized that within a given reservation, everybody who's alive in the year that the first allotment occurs gets an allotment. So the BIA is picking which reservations to allot. They pick one, and everybody who's alive gets one. And so within a reservation, the only reason you'd have a later allotment is you just hadn't been born yet. And so that's essentially the first instrument. It's like, when was the original allottee born? And it turns out if you're born later, you're more likely to get stuck with trust land. The second instrument is a lot more sort of in the weeds to construct, but I'll basically just summarize it here. It's based on this really neat judge fixed effects literature in law and economics. And the basic idea is these BIA agents have a lot of discretion over who to give fee simple property rights to. And it turns out that over this 40 or 50-year period, they're kind of rotated around almost at random. Basically, a new president or a new Congress gets elected, and they reorganize the BIA, and people get rotated around, which means that for each agent, I can see all the decisions they made on all these different reservations about basically their propensity to switch land into fee simple. And then for each allotment, I can then look at which agents it was exposed to and construct a probability that each allotment gets fee simple property rights. And so when we combine these 2 things, we actually find a much larger effect of fee simple property rights. In our most restrictive specification, it's about half a standard deviation, and I'd be happy to talk through the intuition for that later. But I suspect I'm probably getting a little low on time. I didn't keep an eye on exactly when we started. But so I want to kind of highlight a couple other things about the paper, and in particular talk about something that talk about this comparison to tribal land, because that's something we don't do a lot of in the paper, but I suspect it'll be interesting for this audience. So, you know, as you know, if you've read the paper, we think through land value implications, basically by constructing kind of a comparison sample to look at how utilization affects land values off of reservations. We think about mechanisms, and then we look separately at kind of development versus agriculture. And I guess the thing I would say there to motivate what we're going to look at in a minute is that kind of the stylized facts of development on reservations are that prior to 1974 is like all agriculture. Like there's no economic development going on reservations other than agriculture until about the 70s. Then they get this sort of classic structural transformation towards more intensive development. And since 1970, that's really been where all the action is. You can think about casino gaming, oil and gas, these kind of things. More intensive development's been going on reservations. And so what we want to do is we want to look at agriculture as opposed to development kind of over that exact period, which just happens to be when we have our data. So here's kind of a picture of the land value data. I just included some of these things to kind of highlight what we do, and we can circle back and talk about them. In terms of this collateral mechanism, basically what we're able to show is that the effect is much larger. In fact, it's about twice as large in places in reservations that have good access to credit. And the intuition there is that if nobody has access to credit, then the fact that you can't collateralize your trust land shouldn't really be a disadvantage to you. But in the places where there is good credit, or if there is access to credit, trust land is more likely to fall behind because those fee simple landowners are able to get loans, and that's exactly what we find. This is the look at sort of changes in land use since 1974. So we see that this effect is actually getting substantially larger over time, and this is mostly driven by economic development, which is what we show in this table here. This is actually a table I grabbed out of the appendix because I wanted to highlight it for this group. So in each of these years, basically what we're seeing is we're seeing the differential effect of this difference in property rights over time. So we have the 1974 difference in this first row. First two columns are both land uses, and then we focus on development and then cultivation. And I guess what I want to call your attention to here are these two columns on development. And in particular, in this table, we also bring in comparison to tribal land. We don't highlight that in the paper because we don't think it sort of passes muster with the identification police these days. But we do think it's an edifying comparison. And what we find strikingly, and I want to call your attention to column 4, is here you're looking at kind of the growth in land use, or in development in particular, on fee simple versus trust land since 74. And then if we jump down here, we're looking at that same trajectory for tribal land versus trust land since 1974. And what we see is that during this period of structural transformation that's been really critical for some tribes to kind of take off and catch up, both fee simple land and trust land is dramatically outperforming individual trust land. So whether it's sort of fully complete private property rights or it's land that's still kind of communally held and managed by the tribe, it's doing much better than this kind of in-between form of individual property rights with these trust restrictions on it. I will say that like fee simple is statistically different and better than tribal land in this particular comparison, but we think that this is actually a pretty important stylized fact to point out. So to kind of wrap up so that we can have some discussion, we think what we find is what we think is pretty compelling evidence that fee simple property rights do a lot better than these sort of inalienable property rights on reservations. It translates into a lot of money in terms of, if you think about scaling up $5,000 per acre to a 160 acre parcel, that's not trivial. We think there's pretty good evidence that this specifically has to do with access to credit and collateral, and that you're essentially creating what DeSoto would call dead capital in this land because it can't be collateralized. And we think this is a really important cautionary tale for contemporary land titling efforts that sort of have this kind of top-down paternalistic flavor to them. And so I wanted to close with a couple kind of maybe questions for discussion or food for thought, because one takeaway from this paper would be, well, we should have just finished the job and let everything transfer to fee simple property rights on reservations. But we want to be really careful. I want to be really careful to say we know that that's not the only goal, right? There are other reasons why, or there are other goals on reservations besides individual economic development. In particular, land is really important on reservations because it's kind of all these tribes have left as a land base. It could be important for social cohesion. So it's not obvious that we want to just convert everything to full fee simple, and we don't want that to be the policy takeaway of our paper. And that's why I called your attention to this other table that brings in tribal land, because that might kind of be the best option, right? It's developed significantly more than individual trust land, not as much as fee, but you can also achieve these other goals at the same time. And we point out that that's actually what's been going on since about 2014, thanks to a lawsuit, which I'd be happy to talk a little bit more about. There's basically a $2 billion fund to run around and convert these individual plots back into tribal land. And today that's been successful over about 2 million acres, which is about half of what they've gone after so far. So they're having trouble kind of reorganizing this land back into tribal land, which I'd also be happy to talk about the details of that. So we think that this is a really important example kind of in and of itself, because we think economic development in Indian country is important, but we think it raises some really interesting questions about how to get the benefits of creating private property rights while avoiding some of these pitfalls. And so in the conclusion, we speculate a little bit about some of these other models that sort of involve a little bit more communal governance kind of alongside individual property rights, and something that has a little bit less of a colonial feel to it, a little bit less of a top-down feel to it. So I would love to talk about any of those examples, especially if folks in the audience are familiar. But I think with that, I better shut up and turn it over to questions.
Right. Thank you, Brian. Before I hand over to Jess Steinberg, who already has a hand up, I just want to mention that I'll keep an eye out for the queue in a couple of ways. You can either go to the bottom of your Zoom screen and use the participants tab to use the raise hand function, or you can type into the chat box, I have a question, and I'll keep an eye on both the participants list and the chat box. And Jess, you get the first question.
Cool. Can you hear me okay?
You can, thanks.
Awesome. Great. Well, Brian, I think I've told you before, but like I'm continually astounded by the sort of scope and size of this data project that you have been engaged in for a while now. So bravo on that. I want you to say more about the continued tribally held land. And I'm hoping that you can help us understand a little bit more about the mechanisms as to why it might perform more similarly to fee simple than to individually held trust lands. And some of this is a selfish question, which is that I'm particularly interested in the ANCSA, Alaska Native Claims Settlement Act, which essentially gave a bunch of land over to these Alaska Native corporate, for those of you that aren't familiar with it, gave it to a bunch of corporations held by specific tribes, regionally concentrated across Africa or across Alaska. And one thing that's interesting is that every individual member of the tribe holds a share in this corporation, but they can't sell them. They can only give them to their heirs. And so this presents this sort of, there's no exit strategy. So if they're unhappy with the way the corporation has been managing the land that has been allocated to the corporation, they can't really do that much. So I'm trying to figure out like which of these sort of things that Brian's talking about is this most similar to the tribally held sort of outcome, or the individually held trust outcome.
Yeah, so in terms of mechanisms for why they're different, off the top of my head, I think there's 2 or 3 things. I think one is the credit mechanism. So owners of individual trust land cannot use their land for access to credit, and tribes, of course, have sort of other ways of accessing credit besides kind of like a classic go down to the bank and get a loan like an individual would. And so it presents a little bit less of a barrier to economic development in that way, because the tribe, is a tribe and has sort of other ways to pursue financing. Yeah.
But I'm just curious, that would seem like it would depend very much on the organizational structure of the tribe and how power is concentrated or not in terms of how they can actually.
It really does. It really does. So I think that's kind of the second thing, which is that on tribal, so what's interesting is that both tribal trust land and individual trust land is technically the title holder is the US federal government in both cases. In the individual case, there's a real, in both cases, there's a real asymmetry of power, but it's really just the individual trying to deal with like the local BIA agent, and that's still the case. With tribes, it varies a lot from tribe to tribe, how much kind of muscle they can throw around in governance of tribe. Like, there's like a tribe specific relationship between the tribe and the BIA that varies a lot from one tribe to another. I think the other thing that's going on here though, which I didn't say a lot about in the presentation, partly because it takes forever to explain and partly because we don't have the cleanest evidence on it in this particular paper, is that these individual trust lands are subject to this fractionation problem, which is that because they couldn't be written into a will initially, and importantly, because you can't take out a loan or use the land as collateral, this tenancy in common was used as like an inheritance mechanism, which means that every time a trust land holder dies, all of their living relatives get an undivided interest in that parcel. And this is actually like I learned this as a result of writing this paper. This is like really common in agricultural areas in general. So like the head of household dies, and technically, if you haven't written in your will, it goes to my oldest son, it gets divided among, your descendants. But typically what happens in that setting is either they sell the land like as a farm and then they share the proceeds equally, or like the eldest son would literally take out a mortgage on his interest in the property to buy out his siblings, and so the farm remains intact. But neither of those things can happen in Indian country because the land is not transferable. You can't sell it and then like split the proceeds, and you can't take out a loan to buy out your relatives. And so you end up with this fractionation problem we think that's one of the reasons that this comparison where we get this like divergence over time is because the fractionation problem is getting worse and worse every generation. Unfortunately, we just don't know anything about that at like the parcel level. And so we're not able to do a lot with it in this paper, but we do know that that's something that's going on a lot of these trust lands that would just not be an issue on tribal land. Like that's not happening. There's no inheritance problem with tribal land because the tribal government is this entity that persists.
So my last point would just be, when you write your book on this, like using this data set, I would love to know a lot more about like how these politics play out on the tribal end. Because I know I understand the identification problem. I totally get it. But like, this is really fascinating. And I would love to know what are the relevant dimensions of comparison among tribally held land to really understand like what kinds of heterogeneity we're looking at, how they, because I assume they face other problems that are not about fractionization.
Yeah, absolutely. Yeah.
Great points, both of you. Thanks. Dean has the next question. I'm keeping an eye on the queue. If you want in, as I said earlier, just either use the raise hand option or the chat. I'll keep an eye on both. Dean?
Okay, good morning. Thanks, Brian, for a really nice, clear presentation of a big project. You don't spend much time, I'm not going to talk about the data right now, you don't spend much, if really any time, on sort of the theory of why restrictions would lead to certain outcomes. And here, you're sort of asserting, I guess, and it seems plausible, at least in a certain kind of model I have in my mind, that these restrictions would limit incentives for development and so on, have impacts on land values. But if you think about water, let's say, and I know you know about this, there's a literature there that shows that water restrictions make some sense. And the fact, can even strengthen property rights because you basically have a couple of different dimensions of the asset. And so you may want to, because you're sharing water withdrawals from a common basin, you may want to limit restrictions to people in the basin, let's say. So transfer restrictions can be wealth enhancing sometimes. Sometimes they can be not, as it seems to be the case here. Although at the end you sort of kind of redefine what wealth is a little bit in your push away from recommending fee simple ownership policies. So I think the paper could benefit from thinking about that a little bit more. You got this line of thought on investment and collateral and so forth, which again makes good sense, but some sort of clarity on what kind of model is going to generate reductions in value and or use of land, and what kind of model would generate increases would be nice to maybe distinguish a little bit. And I think you want to be a little careful on the fractionation, because as you note, it does emerge in places where it's fee simple. And it happens in Europe where you have fee simple land. I think you're right that the transfer restrictions of the sort we have on reservations can increase the chance of getting fractionation, but it does arise in the American South on fee land. And so there's something else going on there. And it's, what is it? Propensity to use the legal system to drop wills, education. I don't know what it is, but we do see a lot of this fractionation around the world in areas where there's pretty clear right to transfer. So, you know, you don't have to worry about that too much here, but I'm sure you're thinking of other projects. So those are a couple things to think about, and maybe you can get a little bit of a response on a couple of them this morning.
Yeah, sure. Yeah, if you want a little bit of a response, I do think we wrestled with this fractionation problem a lot because, yeah, in the course of just trying to understand tenancy in common a little bit, we discovered this is like a big deal in the U.S. South, and I guess we've convinced ourselves, or at least the story we tell ourselves, is that access to credit in this first generation might be really critical. And the idea I think that we have in mind is that we do know this is a problem that gets worse and worse and worse over time. And so the idea is that if for some reason you fail to resolve this issue in that kind of first transfer where it goes from being the head of household to, you know, several descendants, if it doesn't get resolved there and then it goes another generation, it's just going to kind of snowball from there. And we know on reservations that there just wasn't a way to solve the problem because for a period of time they literally could not write wills. But then even if they could, you sort of had this issue with access to credit. And we think, I mean, I don't know nearly as much about the history of the U.S. South, but I think we have this intuition that there were probably also credit constraints there. And so we think there's this interaction between transferability and collateralizability and having a credit constraint that then could cause this tenancy in common institution to really have some bite, and then it would just kind of snowball from there. But yeah, I mean, your point is well taken. I started this project thinking this was sort of a bizarre thing that happens on reservations and nowhere else, and was very surprised to learn just how widespread it really is in terms of the fractionation issues. So yeah, I appreciate that point.
Yeah.
Bryan, I'm going to ask just a question of clarification about a couple of things. One is, if I have allotted trust land, clearly I can't transfer it to somebody else. That's the very point of the paper. But can I let other people work my land? Is there,
yes.
Is there something comparable to tenant farming?
Yes, with some asterisks, yes. And this is something that evolves over time, and it evolves differently on different reservations. So leasing can occur. It's subject to BIA approval. So I presented a version of not this paper, but a different paper on these same issues. And the tribal chairman from the Crow tribe, Alvin Not Afraid, happened to be there. And he raised his hand and said, yeah, this is a problem. He said, I wanted to, you know, build something on my trust land, and I had to go down to the BIA office and lease it to myself and get it approved by the local BIA agent. So yes, and I guess this is in part answer to some of Dean's questions too. There are, I would say, especially in the last few decades, there's some kind of tweaks at the margin that make this less severe than it used to be, not so much on the fractionation margin, but on some other margins. So one thing that's gone on is that there's now some kind of long-term, like 50-year leases that can be renewed for a 99-year lease on trust land. And so then you're starting to kind of, it's not fully transferable, but it looks a little bit better that way. And that occurs more on some reservations than on others. So Agua Caliente has some pretty nice kind of leasing arrangements, and there's some nice empirical work there by Randy Aki showing that on some margins, you know, it looks about the same as off-reservation land. That's going to be less true in other areas. The other thing that's gone on is that more recently they've sort of gotten creative, and you can potentially get access to credit and sort of collateralize a stream of payments from your land. You know, your collateral is not the land itself, but it's sort of the stream of income from the land, which has allowed some people to get slightly better access to credit markets. So there's some tweaks at the margin, but it's definitely, you know, if you look at starting a farm or starting a business on trust land, you're definitely dealing with hurdles that aren't there on fee land for sure.
And as just a quick follow-up on that, as Jess said, you know, this is a mind-blowing database already, and at the risk of tossing one more straw on its back and making it collapse of its own weight, if BIA approval is required for these kinds of leasing arrangements, that sounds to me like that means there's data. And would there be parcel level data that would allow you to sort of push this question to the next step?
So I think in theory, and I have a funny anecdote about that hopefully won't get anybody in trouble. So Thomas Stratman, who's at George Mason, has a paper on fractionation, and it's on agricultural leases on some reservations in kind of the upper Great Plains. And they didn't have any spatial information whatsoever. It's all like the exact data you're asking about. It's like approvals of the leases, and they know something about the agricultural income, and they actually knew something about how many, you know, fractionated interests there were associated with different leases or whatever. And the thing that I kind of do is to link those kind of data to something with spatial information. And so we approached Thomas and said, how'd you get these data? Do you still have access to them? Would you want to partner? And basically what happened is that one of his graduate students had a friend who worked at the BIA who gave him a bunch of this data when he quit. So perhaps not legally, certainly, like, you know, Thomas was not willing, it was not data that we were able to get access to. I guess I'd just leave it at that. But, which is interesting, you know, I always say that when I've worked on these issues, like the transaction costs associated with land use in Indian country are so interesting, and they become so self-evident just in the process of trying to write the paper, because, you know, you call these people up and you're like, all right, well, who do I need to talk to find out about this issue? And they can't even, in many cases, they can't even answer that question for you. Or in this case, I guess the relevant thing would just be the sheer amount of discretion that some of these like bureaucratic agents have about something as simple as like, will I share data with you or not? So for another project we had, rather than having to kind of construct it from the land records, we actually got a shapefile from the BIA agent of mineral ownership on the Fort Berthold reservation. And he just sent it to us via email. But if you were to try to do that through like a different BIA field office, you might get nowhere. So it's very, you know, the data exists, but they're hard to get a handle on.
Yeah, understood. Thanks. And I'll check with David later to see if that portion of the recording can be edited out.
Yeah, exactly.
For the protection of your sources. It's like the Panama Papers of the BIA. Brian Bruns is in the queue. Brian.
Okay, it was interesting paper to read, and certainly a whole lot of work trying to figure out, you know, what could be going on and control for a lot of things. I want to ask the kind of related question: would there be ways to better understand what this means in terms of the people, including the underlying kind of paternalistic hypothesis behind restrictions, to kind of see, you know, is there a way to use this kind of research design to understand differences between people who did or did not happen to get the allotment, and corresponding, is there kind of case study or other things that give insight into what made a difference, or are there ways that people were able to accumulate, or ways in which people, you know, kind of went bankrupt or got impoverished? And, you know, so those kind of questions.
Yeah, that's a great question. And actually, so Christian and Dustin have an entire other paper on exactly that question. And that's actually the paper they started with. And I was working on land tenure stuff, and they really are focused on the allottees, on the individuals. And so they had built this great database of the Indian agents and all this information about who got the allotments. And I was working with the land tenure data and the public land survey system stuff. And when we realized they could talk to each other, that's kind of how this paper was born. But so let me try to really quickly characterize their paper and not mischaracterize it, because it's still a work in progress. because actually it turns out following people over time is a lot harder than following land over time. So their sort of whole project is based on digitizing these Indian census rolls, which is how we get the birth year for our instrument. And then they link that to various waves of the census. And so what they do is they try to follow people and their descendants over time and look for different outcomes for people that got a fee patent versus people whose land stayed in trust. I do think, as a stylized fact, I think it's fair to say that you see more evidence of people like moving away if they got a fee simple property right. So, and I can say this as like a stylized fact outside of their paper, a lot of the fee simple land ends up being owned by white people, which is like exactly what you know, the people enacting the Dawes Act were worried about. So that there's a lot of that. I think in their paper, one of the things they show that they're really focused on is it really looks like people were kind of jumping through hoops to try to signal their competency to the local Indian agent to get those fee simple property rights. So they find differences in educational attainment at Indian schools and things like this kind of during that period of folks trying to get the fee simple property right. And they're still, I want to say they've linked to like the 1930 and 1940 census, and now they're trying to kind of follow some stuff over time. So that's definitely a work in progress. But if you Google either Christian Dipple or Dustin Fry, they actually presented it at the NBER this summer. So they've got a pretty beefy working paper on exactly this topic to kind of follow outcomes over time. I guess the one other thing I could say about this, so I have a different paper that was kind of the precursor to this paper with Nick Parker and Terry Anderson that's kind of looking at these exact questions, but at the reservation level. And one thing that ended up getting cut from the paper, but that's kind of always been on the back burner for me, is to sort of look at the reservation level. Like, okay, we have some reservations that essentially are completely fee simple, like this thing went all the way. We have some reservations that never got touched, and then we have a lot of stuff in between, is to look at the relationship between how much trust land there is on a reservation and things as simple as population or population density or educational attainment or some of these kind of like social outcomes that you might care about that are not necessarily economic development. And so we started down that path in the other paper and ended up jettisoning it. But the one sort of stylized fact that we had for a while was that it looks like these places that have a lot of individual trust land in particular, not only are they poorer, which is kind of the focus of that paper, they actually have much lower populations. And we think it's because this land is sort of just like kind of useless, dead capital. And so people end up just leaving the reservation because there's so little going on there. So there might be some complementarity here, but that's like very speculative.
Thanks.
Thank you. Brian, did you have a follow-up? Or? Oh, okay, thanks. Gustavo?
Okay, hi all. Brian, so super nice presentation. So and amazing topic. So I was thinking about in terms of policy implications or more kind of institutional implications. I was thinking in two very different directions. The first one is why not consider some kind of collective decision mechanisms to elicitate the preferences over what should be the economic institution or the property right regime, okay? And I know in the case of Mexico that there was kind of a voting decision and it generated a lot of problems. So I'm not suggesting that this is the solution, but maybe to think in that direction if there is room, okay, to think about that. And then the second question is completely unrelated, going very different direction, but I think that maybe your paper has implications that are much broader than this context specifically. I'm thinking about Chinese policies on this kind of 100-year lease. Essentially, these are kind of not full property right regimes. And then, well, people at some point started wondering, or 30 years, I don't remember exactly how, but they start having this kind of same features. It's like, to some extent, you have rights, but not full property rights. And then maybe to start thinking more in a kind of a international comparison of how people solve this type of problems in different contexts. Maybe that could give you an idea of why it's so complicated in the case of the Indian reservations in the US.
Yeah, thanks, Gustavo. That's really helpful. Yeah, so I think this idea of some sort of communal institution, I mean, I know it hasn't worked well in some contexts, but I like the appeal of it because part of the reason I've gotten so sucked into this topic, I keep saying I'm going to stop writing papers about Native American reservations, and then I keep writing more, is the bureaucracy of it is just so like staggering. Like it's just such an interesting kind of top-down, kind of colonial style administration that's so divorced from the realities of the people on the ground. And so, you know, if I had to make some sort of like armchair prescription about this, of having, you know, property rights with some sort of, you know, protections for these things that we might care about, but something other than this individual trust land, I do think that, you know, something that leverages kind of the institutional knowledge and the social cohesion on the ground has got to do better than what we have. And actually Leonard Carlson, who was sort of an early scholar of the Dawes Act and allotment, has some papers from the 80s, you know, using, of course it's the 80s, so like using pretty coarse data on what happened, but his telling of allotment is that you had, you know, so prior to the Dawes Act, it's all tribally owned land. You know, a reservation is just like the tribal nation, the tribe owns it, they manage it. You had almost like what you're describing, like these individual use of the land, and essentially like an informal set of private property rights that was all administered by the tribe. And then the BIA comes in and just kind of like grafts their thing on top of that, and it's a complete disaster, which is why, and Carlson actually shows, again, at a pretty coarse level, but some of the reservations that were doing the best agriculturally prior to Dawes were doing the worst by like the 1920s because of this kind of mismatch between what they were doing and what the BIA brought in. So I do think that that's an important part of the story. I really like the suggestion of looking at the Chinese context, which is a context I know literally nothing about, but I suspect there's some implications there as well that would be worth looking into. So I appreciate those comments.
Could I have a follow-up, Bill, or that's okay?
Please go ahead, and then I've got one more person in the queue, and if anybody else wants in, please let me know right away because we're down to about 8 minutes here. Go ahead, Gustavo.
Okay, so something that I was thinking related to the first question is, what if they come up with a collective decision at the level of the reservation to, okay, whatever is private property is already private property. You cannot do anything with that. But the part that is not private property, to keep it like that or to transform it into private property, and then whatever, you have a referendum on that if you want, something like that. Then that doesn't need to be like top down. People at the ground, they can decide what would be, you know, the choices in this referendum and so on and so far. But then the only thing that maybe the government needs to help is that this is going to be a commitment starting from now and to the future. So that's kind of thing that I was thinking, not to increase the bureaucratic part, but just to give them the possibility of essentially picking their own economic institutions, no?
Yeah, and I think there's evidence that something like that can work really well from the oil and gas context. So one of these other papers I have is on fracking on Fort Berthold in particular. And it turns out that there's a lot of variation in basically the minerals tended to run with the land. And so you have some reservations where the tribe holds like sovereign rights to their entire mineral endowment, and other reservations where it's all fractionated just like the land. And you have these kind of polar cases that we point to in that paper in the conclusion, which is like, if the tribe holds the rights intact, then you can make a communal decision about what you want to do. And you can end up with like Standing Rock, which says, this is sacred, we're not doing this, we're not touching it. And they have the right to do that. Whereas if they had a bunch of fee simple land, scattered throughout, it wouldn't be up to them. And individuals could like initiate this fracking boom without the tribe necessarily being able to stop it. And on the other end of the spectrum, you have the Osage, who grew like massively rich off of their oil endowment because they chose to exploit it, and they did it in kind of a coordinated way. And then the kind of worst of both worlds is something like Fort Berthold, where you know, some people don't want it, some people do. They do develop it, but they develop it pretty inefficiently relative to how it could have been developed if the tribe held the rights intact, which gets into all sorts of like spatial resource management issues as well. But I think it's an important, that's a great suggestion.
Thank you very much.
All right, Angie, you wrote your question in chat, but if you want to unmute, you can just go ahead and ask it. And then this is kind of last call with about 5 minutes to go for anybody else who would like to be in the queue. Just find a way to let me know. Thanks.
Yep. So I wrote in chat because my question was really about the lack of adoption by the reservations of Article 9. You know, in most creditors will consider that an essential adoption to recognize value regardless of source. And, you know, one of my buddies worked on the tribal rights for Article 9, and last I knew, it's still sort of fluttering around and hasn't really happened. And it's, you know, the absence of recognizing transferability is almost, you know, stuck in a property regime, fair enough, but Article 9 moves us out of that and actually doesn't even talk about ownership. You need an interest. And so, you know, that the conflict between the absence of Article 9 and the complete reliance on property is part of the reason why other parts of the United States have moved away from some of these problems, even though you still see fee simple and registries and transferability. The reservations have just not bought into that. So, you know, without the, I guess my main comment is without that within your consideration of, you know, when you mention access to credit and stuff, that it's really much broader than that would be my argument. And I just wondered if you had thought about it.
Can you clarify what you're referring to in Article 9 in particular?
Well, so the entire secured transactions regime in the United States amongst all 50 states depends upon not ownership, but on interest. And the move from the 2000 in 1999 from that belief that it didn't rely upon an ownership interest, but only required an interest like leaseholds and stuff that you're talking about, or life estates. That movement transformed the way we handle in the United States value created through collateral. That occurred in 1999, and the reservations had not adopted Article 9, had not made that shift. And the absence of that shift makes creditors incredibly leery of valuing things in the old property regime because it doesn't match the current existing way that we handle credit in the United States and access to credit in the United States. And so that 1999 is a massive shift in the US that's captured in the time frame that you're talking about, but I don't see it reflected in the conversation.
Okay, yeah, so I really appreciate that comment. That's super helpful. We're actually working on another paper now on tribal secured transactions laws. It turns out they got some model legislation, and so different tribes have different, they basically enact their own secured transactions laws, and they look very different, and we're trying to study that kind of separately from this, but I really appreciate that, and yeah, we should think through what that means in terms of our panel estimates and whether we can kind of leverage something changing in 1999. I appreciate that a lot. That's super helpful.
I'm happy to connect you as well to Bill Henning was one of the people that led that charge, and he's a good friend. And so
yeah, we've actually been getting his advice on our other paper.
Okay,
So.
Yeah, and so, you know, it's sort of a watershed moment to a lawyer is the transition from old Article 2 to new Article 2.
Okay.
Or he'll call it revised Article 2. Okay. Which happened in basically 2000, and you know it's in that time frame that you're talking about. And yeah, if he's giving you advice, then that's the end of me saying anything about reservations, because he's the man as far as I'm concerned, knowing that area, but not having thought about, or not me seeing it in there somehow, even in a footnote that says, hey, look, we see this, but we're not putting it on, is big because it happened during your measuring frames.
Sure. Yeah, I appreciate that. That's really helpful. Thank you.
You're welcome.
And Brian, for your benefit and anybody else, our colleague Brian Bruns has put a link in the chat, and also offered a comment, kind of a callback to last week's colloquium presentation, where Sheila Foster talked about community land trusts,
Right.
and whether and to what extent there might be some comparability between tribal land rights and something like a community land trust. And this group of people can have more fun with any topic than any group of people I know. And the next thing you know, you're out of time. So everybody, please join me in expressing our gratitude to Brian for a really terrific paper and fascinating project and a good presentation today. And thanks everybody for joining. And Scott, I'm gonna let you offer whatever benediction you want to offer.
It'll all be in Latin. Bill, that was fantastic. Brian, thank you so much. I guess just a quick reminder that we have another special research series event this Wednesday. And this one is going to be building off of the great, I thought, polycentricity discussion last Wednesday, this time around in the context of the space commons. So continuing our commons theme with the discussion with our space governance working group. So that's going to be a lot of fun. There's about a half dozen projects that are going to be highlighted. And beyond that, we're hoping for a great discussion. So look forward to seeing you guys on Wednesday. And thanks again, Brian. Fantastic paper.
Thank you. I really appreciate all the feedback.
Have a great afternoon, everybody. /evening/morning. Thanks a lot. Bye.